if you are Mountain or Pacific time, afternoon if you are Central or Eastern. Give everybody just a couple of minutes to trickle in. These systems are always fun. We're sort of lets you in one person at a time as if you're walking through a physical door. Don't quite understand the technology reason for that, but that is okay. Hope everyone is doing wonderful. We'll give it just a minute, and then we'll kick off with some introductions and starting into some various questions. All right. Let's see. I'm going to go ahead and I guess share my screen just so we have a couple intro slides here, and then we'll switch back just so we're looking at faces. Let's see. And we will share. There we go. All right. My screen doesn't really want to share. There we go. Permissions are fun. All right. Well, again, welcome everybody to our Expert Roundtable. So today we're going to be talking about tackling compliance when transitioning to an RIA. So whether you are with a broker-dealer, wirehouse, insurance company, and looking at going independent, if you are with another RIA and have questions about non-competes and such, or just quite frankly, you're just curious about compliance and what compliance in this side of the industry looks like. That's what we are. That's what we're going to be talking about today. So if we have not met before, my name is Alan Moore, one of the co-founders, along with Michael Kitsis, and the CEO here at XYPN Network. We got started about 7.5 years ago now. April will be 8 years. And Travis, you'll have to help me out. I think we've registered north of 1,000 firms now, if I'm not mistaken.
Correct. Yeah, just north of 1,000.
So we have about almost 1,600 advisors here who are part of our network who are all dedicated to serving next-gen clients and doing so as fee-only fiduciaries. But each of them are independent RIAs. And so some of them come to us with RIAs, so we don't have to register everyone. But we have been through this process quite a bit. And just so you sort of have a lay of the land when it comes to the system that we're using, I know this is not Zoom, so just a little bit different of technology. And this slide is just showing a few different areas. So if you click this top button here on the top right, the bubbles on your top right-hand screen, that is the chat. So you can interact with other attendees if you want to chat, ask questions, talk with each other. Questions. So those questions will come to me. And so I'll try to keep an eye on that. So that is that second tab. If you have questions for myself, to be able to then ask our panelists. And then finally, our polls. So we are going to kick off with a couple of polls, one right out of the gate, so you see where those are. And so whenever we say, hey, there's a poll, you have to click on that third section and then answer the poll there. It doesn't just like pop up on your screen in front of you. And then finally, we always appreciate feedback. So at the end of the webinar, there will be sort of a back to lobby button. You go back to that home screen that you saw prior to the webinar kicking off, and you can give us some feedback. All right. So now I want to introduce the panelists who have so graciously joined us today. So I'll run through names, and then we'll let each of them come on and introduce themselves as well. So we have 5 panelists today with a wide range of expertise and experience. So from our screen left to right, Teria, who is one of our XYPN compliance consultants, is a former regulator, and so has lived in the world of compliance and regulation, I believe, most, if not all, of her career, and is extremely knowledgeable about all things compliance. Travis Johnson, who is our Director of Compliance here at XYPN Network and manages our entire compliance team, which includes initial registration, sort of ongoing consulting, additional services and support, as well as ADV updates. Chris Stanley, who is a securities attorney. Nothing today is legal advice. However, he is an attorney and has a background against, I believe, all of his career in securities legal work. And so he is very adept at navigating non-competes and answering questions about just all the legal side of compliance. And then we have 2 members that we're very excited have been able to join us today. So Daniel Wren, the founder of Wren Financial Planning. And so Daniel left a broker-dealer what feels like many years ago now. It wasn't too long ago. And so has experienced this firsthand of making this transition, as well as Stephanie Sammons, founder of Sammons Wealth Management, who also has made this transition in her career. So let me X out of this just so that the slides aren't totally overtaking. Stop sharing my screen if I can. Oh, I wasn't sharing that whole time, was I? Or was I? Anyone know? Could you see my screen?
I couldn't.
No. Oh, look at that. Y'all got to speak up and say, hey, I can't see your screen. I was showing faces, so no big deal. Sorry that technology has failed us. So I gave a quick introduction, but I would love to go through and just let everyone give any additional context that would be helpful for our conversation today. So Teria, I'll let you give a quick intro as well.
Hi. Again, my name is Teria Heng. I used to be a financial examiner at the Texas State Securities Board for about 6 years. Prior to that, I worked as a compliance consultant at various consulting firms / law firms, and for the most of my career. And here at XYPN, I am a consultant. So I help with a broad range of compliance needs, including compliance coaching that we offer here at XYPN, which is working one-on-one with a compliance consultant on an ongoing basis.
Awesome. Thanks for that, Teria. Chris?
Good afternoon, everybody. Chris Stanley. I'm the founding principal of Beach Street Legal. We're a law firm and a compliance consultancy that serves exclusively RIAs and assists them with transitions, M&A work, general compliance matters, corporate legal matters, et cetera. Appreciate the opportunity to be here this afternoon.
Absolutely. Thanks for joining us. Travis?
Travis Johnson. I've been with XYPN for 5.5 years now, from when we brought in compliance, shortly after we brought compliance in-house. So I lead the compliance team through, like Alan said, the delivery of just our various services and resources, from registration to ongoing consulting support, and then just the development of any educational compliance material that comes along with that.
Fantastic. All right. And Daniel?
Yeah. Hey, guys. I'm Daniel Wren. As Alan had said, I left firm, I guess it was 2014, a big insurance firm. I'm sure most of you know, Northwestern Mutual. I brought my desk.
No one's heard of them.
I brought my desk with me. We were just joking about earlier, literally, and started my firm. Then we worked mainly with physicians all over the country. So that's a little bit about me.
Awesome. Thank you, Daniel. And Stephanie?
Hi, I'm Stephanie Sammons. My firm is Sammons Wealth Management. I'm based in Dallas, Texas. I was with big wirehouse firms for most of my career. 10 years with Merrill Lynch, 5 years with UBS. I left the industry for a bit in that capacity. I stayed in the industry, but I wasn't a financial advisor when I left Merrill in 2009. And then I relaunched. I became an RIA, and my firm has been up and running. I'm in my 4th year now.
Awesome. All right. Thank you again for everyone who taking the time to be on with us today. These are the leading experts, either through experience or by career, in all basically anything to do with compliance and transitioning to the independent space. So excited to have everyone on for us to work through. So if you will, we're going to kick off with our first poll, partly just to show you where the polls are. So I just triggered the first one. So if you go to that 3rd tab down, again, you have the chat button, the question button, and then the poll button. If you go there, you should see a poll in front of you. And the question is simply, what's stopping you from going independent? All right. What are the things that are top of mind for you? What's holding you up? Not sure how to run a business, and it's really about business ownership. And it's like, how does that process work? I don't have the resources, whether that be, financial or information, not sure how to manage the finances of the business. I'm scared of compliance, fear of going alone. This is a very common thing, particularly for those of you who have worked in an environment where you've had other professionals around you to be able to ask questions, to be able to help you through that process, or all of the above. Just all scary, right? Because entrepreneurship is scary, and we don't ever want to downplay that. We don't want to make it seem like, oh, it's like super easy. Just join XYPN and just like launch your business. It'll be super simple. Like, it is hard. Entrepreneurship is a heck of a roller coaster. I think Daniel and Stephanie and Chris, all entrepreneurs here that can tell you it's a tough journey, and we're not here to tell you it's going to be easy. Our goal is just to empower you with the information, to be sure that you have the right information to be able to move forward with whatever is going to work for you and sort of your goals with your life. All right. I'm going to close out the poll real quick then, and we'll see what happens. Does it show up? So it does not. So looks like a pretty even mix, actually, between all the above: fear of going alone, handling compliance, don't have access to resources. Pretty wide range, which is very typical. This is fairly common from what we see from folks who are looking and evaluating whether or not going independent is going to work for them. So, we have an agenda of sort of a few different sections, and I've got some questions that sort of we came up with that we wanted to be sure our panelists are answering, as well as questions that came from you. I'll try to monitor the chat and just try to keep it cohesive in terms of the questions that we're answering. But in the end, this is a group that is able to take this a lot of different directions. So we will kick off just around sort of the topic. One is just like, what does transitioning look like? And start with the one question around eliminating trails. So many of us, come from a world where we have existing trails, whether that be from 529 plans that we set up or annuities that we've had in place, various insurance policies, whatnot. Sometimes we inherited them from someone else. Sometimes we sold them. Either way, and we're saying, hey, we want to go fee only, and so we want to go the RA route. We don't want to have an insurance company or broker dealer affiliation, but we have these trails. What do we do? So Chris, I'll let you kick off with sort of when an advisor is talking with you, like, what are my options if I have all of these trails, different types of products? Like, what can I do with them when I'm trying to go independent?
Sure. I mean, I would say step number one, frankly, is just to do an inventory of the product types, the structures that might be in place with various different other third parties insofar as the trail source, and to identify, at least from what I see, one of three potential alternatives, again, speaking at a high level. Number one would be to, frankly, just do a partial book sale to a willing buyer who perhaps could have further relationships with those clients from the commission business going forward. They could be the rep of record going forward, and can more or less be as the servicing rep for that particular product type or limited relationship. The second option could be looking for fee-based alternatives for those particular products that you're collecting trails from. You'll want to make sure, of course, that converting the client from a commission product to a fee product is in the client's best interest, and not just simply so you can sort of clean up your house and get everything over to the fee-only world. But that's certainly an alternative as well. And the third option is to potentially leave those trails behind, for lack of a better term, but retain view-only access to those particular accounts. So at least as a advisor, you can view them, you can view balances, you can view holdings, and you can still incorporate those into a financial plan or into other investment management strategies. So at least at a high level, those are the three primary alternatives that I see.
Okay. And just real quick, who is the bobblehead behind you? Is that yourself? It's not Kitsis. I know we had Kitsis bobbleheads made at one point.
That's actually a bobblehead that my team had made for me. They apparently took a picture of me, sent it off to some company that made a bobblehead. So go figure. It's probably hard to tell, but I'm giving a really cheesy thumbs up. So
no, I love it. That's awesome. I just see him watching over you. So
yeah, exactly.
Travis, anything to add to Chris's comments, just in what you've seen in helping advisors make this transition?
No, those options Chris mentioned are really what we see advisors do on a regular basis. I think it's really common for advisors that are making that transition to connect with either an advisor in your network that kind of, as Chris mentioned, that's willing to be a willing buyer and further those relationships on that side of the business. We do see that come up time and time again from advisors that are making the transition.
Okay, fantastic. And then Daniel and or Stephanie, just what was your experience? Did you have trails that you needed to eliminate or sell off, or what was your how did you handle that part of the transition?
I definitely did. Part of it was straightforward. Like you just Northwestern Mutual has more strict protocol, so you just lose out on it, and because I wasn't there long enough for vesting purposes. So that was easy. The other part of it, I just left. So I did none of the three options, which I probably should have done. So there's a fourth option, and it's probably a dumb choice, but just leave it there and do nothing about it. So that's what I did.
Okay. Were any of those other options actually available to you with Northwestern structure? Do you know?
I think so. I don't know. I left pretty quick, so I didn't explore it enough to know. But I think that they have like a system where you could talk to other advisors and work out a deal. But
okay. Stephanie, what was your experience with trails?
Yeah, I really didn't have that issue since I had a kind of a hard stop, walked away. I was in management as well as being a financial advisor. So, there was a gap in time between when I left and then when I started my own firm later.
Okay. So not something you had to deal with.
Right.
And sorry, just to jump back in, I think Daniel made a great point as far as, exploring the option of whether you can even sell your commissionable book of business. I think a threshold question is really, is it your book to sell or not? Is that something that belongs to the BD, to your corporate firm, et cetera? And there certainly may be restrictions in place insofar as client ownership, quote unquote. And I know we'll probably get into that later, but I think that's an important thing to underscore that Daniel brought up as well.
Yeah. I think the answer is always review the documents before you sign them, please. Because too often we sign documents to get a job and then we look back and go, oh, that's unfortunate. But yes, we'll talk more about that. And actually that leads into sort of the second theme that we hear a lot from, and that's just like, how do I handle my non-competes? And I typically signed this document, 4, 5, 6 years ago. Here we are. What do I do with it? And so back to you, Chris, as well, just from a legal perspective, and just how do you advise, advisors on what to do with a non-compete if they have one? And I guess, do you have a rough idea of like what percentage of advisors tend to have a non-compete? I feel like it's most, but maybe not.
Yeah, I mean, my experience is anecdotal at best as far as the clients that we see and the conversations we have, the documents we review, et cetera. But it is, I would say, the majority of the case. I would ballpark it at maybe 3/4 or so. Some are enforceable, some are not. Some are a couple paragraphs, some are 10 pages. So they can be all over the map, frankly. But when it comes to the document that you have signed with your current firm, it can take the form of a rep agreement, an employment agreement, or there might even be a separate document that just is entitled a non-compete or a non-solicit, a confidentiality agreement, anything that would more or less be under the umbrella of what's referred to as a restrictive covenant. In other words, a promise not to do something, like not to take client information, not to solicit clients, not to compete with the firm, et cetera, et cetera. So step number one is, which is not an easy question to answer sometimes, is do I even have these documents given that I might have signed them decades ago or years ago? Number two, is there a way for me to obtain copies of them without setting off any sort of unnecessary alerts or triggers back to the home office? And then once you do have the documents, if you don't already, the devil's really in the details. So at least as far as what we've seen, the primary contents of these restrictive covenant agreements will have confidentiality provisions, which are very much enforceable and are potentially variable on a state-by-state basis, but we also have to contend with Reg SP. But by and large, confidentiality obligations are going to be pretty broad-based and non-controversial. There's also the potential for there to be a non-solicitation clause, which is more or less a restriction that's imposed on the departing advisor's ability to recruit or take away or encourage clients to leave the former firm and come with him or her to the new firm. Those are enforceable in most states, but not all, California being a primary holdout that generally speaking doesn't enforce certain restrictive covenants with certain carve-outs, unfortunately, or fortunately, depending on what side of the table you're on. But it all comes down to whether these restrictive covenants are reasonable. And unfortunately, reasonableness there's no bright line test. It's unfortunately usually determined by a court. Rules can vary state by state, can vary based on case precedent, et cetera. But that's sort of the second category that we commonly see. Third is a non-compete, which is a more aggressive provision that more or less says, even if we as the departing advisor don't recruit former clients or solicit them or encourage them to leave, we're not even allowed to set up shop across the street and open up an RIA or open up a business that is competitive with the former business. And so those on a sliding scale tend to be, more heavily scrutinized because it impairs a person to make a living in their chosen field of work. And then some other ancillary provisions that we sometimes see, which are not as controversial, would be things like a non-disparagement clause, which more or less is, hey, don't badmouth your former firm on the way out and cause a messy situation. So at a high level, get the documents to the extent possible, review the documents with, an eagle set of eyes and understand exactly what the details are, what you can and can't do. And then I would say the other thing that could potentially come into the mix is whether it's going to be a broker protocol transition. And I know that's a whole other separate can of worms, but in a nutshell, what it refers to is a transition that is between your former or soon to be former firm and the destination firm, both of which are members of the broker protocol, which is a more or less voluntary agreement amongst member firms that allows you to take certain client information with you, a certain limited amount of client information with you, without breaching confidentiality or other restrictive covenant provisions. So again, I don't want to derail the conversation. I feel like I've been rambling a lot, but that in a nutshell is what to keep an eye out for.
No, super helpful, because it addressed actually a couple of questions that we had submitted from attendees, and one which we were going to add a question about, but you sort of already addressed this, which is how do we even find out if we had a non-compete? And so the answer is tread lightly. Because these aren't, they're not necessarily just stored on your shared file or shared folder system. This is probably something you could request from HR. And I don't know if there's any legal ramifications from HR mentioning to your direct manager that you made such a request, but in the end, maybe you're at a big enough firm that they don't care. But and another question was that was submitted was around just client data and like, can I take client data with me? Which again, you answered, which is go read the clause. I'm curious, what type of attorney do you recommend? If I'm an advisor, I have a non-compete, I have a stack of paperwork that I sign, like what type of attorney do I talk to in order to review that? Like what is their specialty that I need to be looking for?
Sure. And actually, if you don't mind, one just quick comment on the, what client information can I take with me? I would say just as a standard across the board starting point, your running assumption has to be pretty much close to nothing. And you have to look for some sort of permissibility in your confidentiality provision, or whether it's a broker protocol transition, whether there's some sort of other carve out that you can afford yourself of. But generally the starting place, absent something to the contrary, is that the client ownership and the client information is the property of the firm and not as you as an advisor. Some advisors, did a great job negotiating, or maybe intentionally, unintentionally have an existing agreement where they, as the individual natural person advisor, own the client data. If so, great. But the default assumption should be, it should be a very limited amount of information, if any, that you can take with you when you depart. But to answer your specific question, typically you'll want to engage somebody that has an understanding of, being very detailed in terms of reviewing contracts, and then also a understanding of whether the contract provisions are enforceable or not. Because fortunately or unfortunately, I've seen contracts that, in my opinion, were either intentionally vaguely drafted to leave the reader unclear about what particular things they have to do or not do to comply with the agreement, or they're just frankly overreaching and clearly so unreasonable and harmful to the employee that they would never be enforceable in a court of law. And I wouldn't be surprised if some firms take the position that, hey, we're gonna draft a contract that's so patently unenforceable just to, for a scare tactic, or to prevent people from spending a whole bunch of money on attorneys to even take this to court, and have it just moot the entire process and keep our clients close. Contract specialty, and then also to the extent that there are specific provisions from non-solicitor, non-competes perspective, somebody that's familiar with the enforceability in the particular state.
Okay. And then last question as it relates to non-competes, and we'll move to a different topic, but that is, we had a great question around that, many times non-competes give a radius that, you just can't operate within 20 miles of our office or something like that. And so just how have you seen that applied to virtual based businesses? Is it like, oh, well, I don't have an office, I work from home, but I live 5 miles from the office. Like, is that stuff fairly enforceable? Like I need to move to get outside the 20-mile radius, or I just shouldn't solicit clients within 20 miles of my old employer? Like, how does that even end up applying to financial planning firms, particularly those who have an online presence?
Sure. And this will go exactly to the devil's in the details as far as how the contract is drafted. If there's any sort of nexus to where you're physically doing the recruiting or the soliciting or what have you, or where you're allowed to set up shop. But unfortunately, this is one of those areas where technology and virtual work and brick and mortar office buildings and whatnot are not really in sync with a robust case precedent or case law in terms of purely virtual work. So there is some reasoned judgment that has to be made and introduced to these decisions on what you can and can't do. But often there's not like a bright line test, if you will, that you can refer to for a purely virtual practice. But what I can say is that, having a website that's accessible to anybody in the world, I mean, that in and of itself sort of takes off the whole, mile radius restrictions that might be in place. So I realize that that's probably not a very helpful answer, only to say that there is some reasoned judgment and asymmetry as far as the realities of what's going on versus case precedent in the courts.
Chris, you answer questions like an attorney, which is, well, there's 47 different possibilities. And unfortunately, like you said, devil's in the details. So this is, it's why it's so important. And I know for many of you, it's too late. But encourage your friends as you're changing jobs. Like, you need to review what you're signing. Non-competes are not a bad thing. They're not a negative necessarily. And typically the advisors that I see get the most upset about non-competes end up like building a business and then hiring employees and making them sign non-competes because you realize as a business owner, you just have a different perspective than when you're the employee that's signing these documents and why they matter. However, review it before you sign it. Talk to an attorney if you need to. Sometimes I think employers will even, give you some resources, some financing to help pay for said attorney if you need, but an hour or two with a really good attorney could save you a whole bunch of money and heartache and lawsuits on the back end. So, all right. So transitioning the conversation just a little bit, I want to talk about, sort of the timing of what does it take to start a firm and then do this transition. So Teria and Travis, y'all have done more registrations than most probably in the industry. So can you talk to me about whoever wants to take first stab at this, but just the timing that I should expect when I'm thinking about launching a firm? And we'll talk state registration because that's our specialty. The SEC can be a little different, but in the end, we have 50 states that we're registering into with 50 different sets of rules, many times unwritten. And so, just what has the team's experience been with sort of the timing of that registration process?
Yeah, I can touch on this initially, and then Terry, feel free to jump in with any further comments. Generally, so when you're planning to break away from whether that be a broker dealer, corporate RIA, another, or wirehouse hybrid. It's, once you've done what we just talked about, you're aware of what your current arrangement is and what that looks like. Timing the transition, knowing when's going to be that final date, or when are they going to file your U5? Or are you going to be prepared to become unregistered with that firm? I know depending on your current situation, some broker dealers will, some large wirehouse and broker dealers may escort you basically out the door as soon as you provide notice. Some smaller shops or that just have different views on that may allow you to stay on, provide notice, and maybe give some flexibility around what you can do during that time. So once you have an idea of what that looks like, which may be influenced by the timing of the registration actually in your state. Unfortunately, it does vary across different states in the timing of registration. Say on average, we see it take anywhere from 8 to 12 weeks. There's certain states that if everything else is done as needed in that initial application to register in their state, you can get it done in less time, 5, 6, 7 weeks. Overall, the overwhelming majority are within that 8 to 12 weeks. Once you make that transition, or once you're preparing to make that transition, you have the compliance documents drafted and filed with the state. They're going to go through their review process, which can take, some states by statute have to have it turned around in 30, 60, or 90 days. Depending on their volume and staffing, they may take up to that full amount of time. There's been a few states that are pretty consistently at or beyond that 12-week time period. In those cases, the advisors that we work with, we try to set that expectation going into it that, that there may be several rounds of comments and questions in order to get through their regulatory review of your firm brochure, client agreements, any other supporting documents that they requested as part of that application. But really what the process looks like is preparing your documents, getting those submitted with the state securities regulators or the SEC if you're registering at the federal level, having them go through the regulatory review process. There's going to be some back and forth with the regulators over that period of time. And then ultimately, once you've addressed their comments, they don't have any issues with your application, is when they'll move forward with approving your firm and then those representatives that are going to be registered under the firm through the Form U4. Terry, any other comments that you want to add from your experience on that in terms of timing or
yeah. Some advisors, when they first get registered, are still employed with their soon-to-be former employer during the registration process. So they don't want to lose the revenue that they're generating. And then essentially, so there is kind of a risk during that registration process. But once the firm gets approved is when typically you would put in your resignation letter, and then resign, and then we would file your Form U4. And once your firm is approved, essentially, that becomes public the next day via the SEC's disclosure website.
So I would say it's a great point there, Terry. I think in addition, there are a couple states, keeping in mind that different states have different regulation and kind of rules within that they're following. Colorado is a state that is, really very, very easy to work with. However, they will not start the review of your application until you've submitted your Form U4. So there are certain states where you have to do some work or reach out to a consultant on the front end to kind of get an idea of the expectation in the state that you're going to be registering in for some of those factors, as you may time your transition differently if you're in a state that requires certain information before they're going to move forward with your regulatory review.
Yeah, I mean, you're speaking to an interesting point because, and I am no compliance attorney or compliance consultant. So my understanding was when you filed your ADV with the state, your U4 got filed with it, and the U4 filing is what tells. I mean, a lot of firms have alerts now set up. I mean, and my understanding, the bigger firms use FINRA's API to monitor whether or not your CRD number through your U4 has now been attached to multiple firms. Is that not the process? Does U4 not go with ADV initial registration? Can you do that later, or is that state?
Yes, you can do that later. It is two separate filings. You file the ADV through the IARD system. All of this is done through the FINRA gateway, the regulatory portal that's used to administer these filings. The ADV is filed to initiate the firm's registration in the appropriate jurisdiction. The U4 will then be filed to register someone under that firm. In many states, there are a handful of states that will approve the firm prior to that filing. I would say that I wouldn't say that it's the most common, but there are a handful of states that we work in regularly that will allow that to happen. You just can't operate. The firms may be registered, but you can't operate under it until you're registered with the firm. So yeah, the Form U4 we can hold off on that until the advisor is ready to notify their firm, which in that case will eventually lead to the Form U5 being filed and terminating their registration at the current employer. Then we can file that Form U4. One of the things we tell advisors, you don't want filing the Form U4 to be what notifies your current employer. It's never going to go
coming from you.
I had a comment about the U4. I had kind of an interesting experience with it because I'd notified my firm early in on the process, and they were favorable and everything was smooth. I guess I notified my office within the big firm. And so compliance people I was working with at the time were like, okay, we'll go ahead and knock the U4 out because they already know about it. They went ahead and filed it. And like the second after they thought, it was like very quick after, the home office people are calling me and they're like, you're done. Like, you got to leave today. And I was like, hold on, we're not quite there yet. And we had to undo it. And so they are watching.
Yeah, that's a great point, Daniel, is especially if you're within a larger firm and you work closely in a branch office, you have a compliance manager or two, they then wirehouse, the broker dealer, and who kind of their compliance team and the people that do that supervision, then you are relying on someone that you've notified your manager or that the person in charge of supervision of your office. You're relying on them to then communicate that information to the home office, who ultimately is going to probably make the call.
Yeah, a lot of communication levels, and just understand that like nothing you do will fully protect you from the wrath of home office. Okay, sometimes home offices are kind, many times they are not. I mean, we had one firm, it was prior to XYPN, but someone that I know, they got sued by their prior firm because they went and looked up when their LLC filing had been made versus when they had registered. And so the LLC filing, many of you file 6 months, 12 months, 2 years before you actually launch a business. You're just locking in the name, kind of getting started. And so they went and said, oh, well, you've been operating for 2 years while you were employed here. You didn't disclose it. And so they threw a bunch of lawyers at them. And just understand there's nothing you can do there. Okay. Like it's something you need to be prepared for. It's why we don't recommend, like, don't launch a business if you have zero money in the bank, because you just need to know that it's possible you're going to get a $5,000 or $10,000 legal bill. Hopefully not, but it does happen. So we don't want you to be like super shocked and surprised when that happens.
That's an important point there too. And Chris, I'm not sure if you touched quite that deeply on in the initial comments around the documents to review. Also making sure you review that current firm's policies and procedures, or the compliance manual around outside business activities. We've ran into advisors making that transition that within their current firm, it's without prior authorization, you cannot prepare to enter into outside business activities. Usually, I think this is more non-competes, preparing to enter into competition with. But there's been those firms that have that also worded in their policies and procedures around OBAs, that if you are preparing to enter into another business activity, it needs to run through the compliance and get approval. So, and that can be interpreted as setting up that LLC, setting up your entity is preparing to enter into a separate business. And we have seen, it's pretty rare, but that it is, seems to be a common practice, just not as frequent for BDs and larger firms to review this state, the states in which the reps are located, the business search website around any entities that are registered in their name.
Yep, that's exactly right. Oh, sorry, Alan, go ahead.
Yo, you're good. I was going to ask Stephanie, did you have any experience here when you were launching your firm, when it came to just sort of the transition in the process and what that looked like for you?
Yeah, a couple of things come to mind. I mean, if you're at an existing firm and you're contemplating leaving and doing this, it really, really helps to have a good relationship with your branch manager or whoever, is in charge of your office. I had a deal when I transitioned from Merrill to UBS where my boss sort of gave me the weekend when I left on Friday, and I was able to reach out to my clients because it was sort of a wink, wink, nod, nod. And then I was on the beach, as we call it. I had a TRO slapped against me for like a month. And so I couldn't do anything during that time. Now, all of that has changed with the broker protocol system if you're moving from wirehouse to wirehouse. But the one thing that came up when I left Merrill and was contemplating starting my own firm was what to do with all my licenses. I had a series 3, 7, 9, 10, 63, 65 insurance. And ultimately, I had to let every single one of them go. So that was sort of painful because of all the studying, to rack up all those licenses. Since I was a branch manager, I had to have some additional ones. But that's something to know about, that I don't know what the rules are now, whether or not you can park a Series 7 somewhere. You're not going to need it as an RIA. You'll need your 65 and or your CFP designation. But I saw somebody mention that in the questions. Yeah. So it's just something that,
thanks for addressing that.
Mm-hmm.
Yeah, Terry, you were shaking your... Oh, go ahead, Stephanie.
Sorry, Alan. One more thing. I gave myself like a year between the time I applied for registration, and the time I sort of opened for business. And I would just recommend giving yourself enough time to figure this thing out, figure out how you're going to run your business, what your systems are going to be, your technology, and that will really help you hit the ground running. So that was it.
No, that's great. I appreciate that advice. Terry, you were shaking your head, and there was the question about Series 7. And I know there's been some recent proposals, but I don't know if they've gone through. So can you speak to what it means to hang your licenses, which is what we could do back in the day, but how that has changed?
No, I don't. There is no way to park your license unless you're registered with a broker dealer to. And if you are going fee only, and especially if you're joining our membership, unless you can't be registered with another broker dealer. Fee only. Not to say that an RIA can't be duly registered, but to be fee only, you cannot be registered with another broker dealer. So after 2 years, your Series 7 will lapse. So the only licenses that stay active is the 65 if you have the 65, and then you need a professional designation. It's a 1 out of 5, CFP being the main one that can be used to register you as an IAR.
Yeah, and I know there was a proposal to allow it to be 5 years instead of 2 years because, Indian recognized there's 300,000 financial advisors-ish in any given year, and 33,000 of them drop their licenses every year. 33,000, 10% of registered reps drop their licenses every year. And so FINRA is trying to figure out how to keep those dues coming in. So I think they're looking at extending that to 5 years. But currently, yeah, you get 2 years. And I would look at it as you got a 2-year window to see if this thing's going to work. Now, don't expect to be making 7 figures within 2 years, but it gives you a little bit of runway to just see like, hey, is this really what's right for me? Am I happy doing this, or do I need to put myself in a situation where I can use those licenses again? And to Terry's point, that just means you have to work with a firm that has a broker dealer affiliation. Back in the day, and quite frankly, I'm not even sure when this was. This was before my entrance. You could park your licenses with some random BD and not be with them. FINRA eliminated that years back. So you'll hear that sometimes, like, oh, I'll just park my licenses. But unfortunately, that is no longer the case. All right, well, we'll create a little bit of an intermission here. So if you'll go over to the poll section, I just opened up a new poll that will sort of lead into our next conversation. That's just like, what scares you the most about compliance? I guess we didn't say it doesn't scare me, but for the most of us, myself included, no matter how much you know about compliance, it still kind of scares me, just because in the end, there's a lot to it. So, I don't know what I don't know. There's just all these unknowns when it comes to compliance. I don't know who to go to for help. The legal side of just like, there's just so much legal, so many ways to trip over, an issue, just the amount of work that, and you can think of this context of just like, if you're thinking about going independently, if compliance really is a concern, like what is the primary reason, that it is a concern? So, and of course, all the above, which so far seems to be one of our more popular answers. So I'll give you just a minute there to finish that poll out, because what we want to talk about next is just sort of the ongoing compliance needs when it comes to a firm. So actually, we've had a couple of questions. So I'm gonna throw a little curveball in here. I'm actually gonna start with the registration process. What triggers the need for registration? And then we'll talk about the ongoing compliance. So also, I'm going to close out the poll. Thanks, everyone, for jumping in there and answering. It says, I don't know what I don't know, overwhelmingly the winner, and then all the above a close second, and everything else distant, 3rd through 5th. So thanks for that. So Terry, I'll start with you since you're working so closely with advisors on through registration process and on an ongoing basis. We had a couple of questions. Get to them real quick, so I'm reading them correctly. Just related to the question was just sort of overall compliance issues and pointers if you're managing less than 5 clients. I hear this a lot. The de minimis rule. So one, maybe speak to what is de minimis and why are we speaking Latin here? What is de minimis, and does that apply to new registrations, or does that only apply to second state and like when I have clients in multiple states? Can you just talk a little bit about that?
So you are going to need to register in your primary place of business. So I think some people think about, working remotely or traveling, but you have to designate a principal place of business. And so in that state, that is going to be what's state, and so you need to register there before you can register anywhere else. And that's regardless of the number of clients you have. And
so
then
with one
after
client,
that,
so if I have one client, do I have to be registered?
Yes.
Ideally with zero, but okay, just double checking. Except, is New York still weird here? Help, maybe Chris or Travis, if you know that. Isn't New York the weird one?
New York is weird in a different way. So
Okay, sorry, I derail you there.
Register your principal place of business, and then any other state that you have clients, you are allowed up to 5 without having to register in that state. So you can serve 3 clients in another state, or 4 or 5, but once you reach the 5, you want to start registering in that state. You can't go more than 5. So you can't have 6 clients in another state unless you are registered. There are a couple of states that is called de minimis. So that's de minimis. There are a couple states who don't follow de minimis, and that is Texas, which is a little tricky there, where even at one client, you have to do what's called the notice filing there, which is essentially just paying a fee and letting them know that you're doing business there. And then Louisiana is the second state where you have to register there. That's for state registered advisors. If you can go up to SEC. So to be SEC registered, you need 100 million assets under management. If you know you already are going to have 100 million assets under management, you can go straight to the SEC. You have 120 days to move those assets over to reach that 100 million, if that's your initial registration. New York is special in that if you have 25 million assets under management, you can go SEC. So those are them.
Yeah, and I don't know why I was remembering, and maybe Chris or Travis said, am I just like totally on left field? Like, was it New York or another state that allowed you to work without being registered up to a certain level?
Yeah, so there actually are, I think, maybe 2 or 3 states. Chris, correct me if you think if it's a different number there, but applies to if you're not holding yourself out as publicly as an investment advisor, then you don't have a website. You're not really actively soliciting your business to the general public. Then you can avoid registration up to a certain point. Do you have any other points?
Yeah, I was definitely aware of New York on that front. It was the only state I was aware of where the de minimis applied even from day one, meaning that you could have up to 5 clients in New York and not be registered, so long as those clients were in New York and a couple other conditions were in place. But as far as the vast majority, and New York is quirky in a lot of ways, as Terry mentioned. Texas is quirky in a lot of ways. Louisiana, you can add to the list. This is, again, one of those circumstances where state by state registration quirks can differ. But New York, there is still that initial de minimis threshold, but do not apply that across the board to most, if not all, other states. The one other comment I'll just mention, because I did run into this in a previous instance, is with respect to the 5 client threshold, you technically have to get approved by the state before you take on your 6th client, and not just file the paperwork before you take on your 6th client. So don't think like, oh, I'm at 5, I'm going to start the registration process, then I'm off to the races to take on clients 6, 7, 8, 9, 10. No, you got to kind of hit the pause button, hit the brakes, get approved, then you can go 6 and above.
And is taking a client, would you consider that a signed agreement, or would you consider that payment, services rendered? Where would you draw the line there?
It could be a combination of the above, but generally I would refer to the agreement, because that's where you're contractually agreeing to provide services, and ostensibly you're not getting paid until the client is signed on the dotted line. If the client is paying you without an agreement in place, there may be some other issues we need to chat about.
Exactly. No, and I think it's important here just to recognize that, again, I was sort of joking earlier, 50 states, 50 different sets of regulations. And many times regulators inside the state don't interpret the regulations the same. We've had situations where the registration group and the ongoing compliance group don't talk to each other and they don't agree on things. And so something can get approved and then hit on an audit. And it's why I would recommend many compliance firms out there only work with SEC registered firms for a reason, because there's only one set of rules and they're fairly consistent. And so whoever you end up going with for compliance, whether that's here at XYPN or with Chris or with other, ask them how many times they've registered in the state that you're registering in and their experience there, because they should be able to speak to some very specific instances in your state. because every state has nuance. So just a tip is be sure you're working with compliance consultants who have worked in your state before, or are very knowledgeable about state level registration, because it's almost just a different ball game. It feels like sometimes than SEC world. Terria, how long should I anticipate the registration process taking? So I know every state's different. But what are we seeing in terms of length of registration, sort of on the minimum, the maximum, and sort of the average, if you will?
I would say weeks from application to approval. There is more time that's needed, though, in order to submit that application. So there's prep in terms of documents that you need to submit for the application. And of course, as you said, that time can be longer depending on the state that you're registering in.
And then what about sort of what Chris was alluding to earlier with sort of getting a second state? So I'm already registered in the state of Montana. I want to go work with clients in South Dakota. I file that. What should I expect? Is it the same process, 8 to 12 weeks? Is it faster to get sort of a second state added to my ADV?
Yeah, and I can touch on that a little bit. In general, once you're registered in your home state, or the state where your primary place of business is located, I mean, every state, again, has their own review process. There are, in many cases, they're going to want to see your ADV, copies of client agreements. Assuming you don't have a place of business in that state, there may be certain things they're not quite as worried about, but usually it's the ADV, your firm brochure, copies of client agreements. There may be other supplemental documents based on whether or not you have custody, discretion, and some other matters there. But in general, that review, I would say, it's not really starting from scratch. 8 to 12 weeks commonly includes, preparing filings that are then going to be submitted to states. Now that that's done, I would say that, in our experience, the many additional state registrations we've done, it can range anywhere from 3 to 5 weeks in a lot of states. And then there's those half a dozen, maybe 8 to 10 states that do always take, 6 to 8 weeks. And then, depending on, and a lot of this really does depend on their volume of registrations and applications they have in that state, their staffing, and then also just the application you're submitting. If you're registering in a state that just isn't familiar with your business model, they may have a lot of questions on it. There are states like Washington State, Massachusetts, Kentucky to a certain extent, where during the application process, they have just an abundance of questions they're asking, in some, to give them the benefit of the doubt, to really just make sure that you're understanding the contents of your documents, and that the information disclosed is relevant for your firm.
All of our attendees, did you notice the faces of our compliance folks whenever he mentioned state of Washington, Massachusetts? There was like, every state is unique, right? We have, and try to not pick on any specific states, we have some states that take a lot longer. Like we've seen registrations take up to a year in one specific state, I believe, just because of their process that is very not typical. But I remember now, it feels like the olden days. So back in 2012, when I registered in Wisconsin, they just pushed it through. I don't think anyone reviewed my documents short of just like some check boxes. They said, like, we'll see you in 6 months for your audit. And so the registration team's just like pushing them through. It's the audit team that shows up in your first 6 months, and then 2 years thereafter or 3 years thereafter that do the deep dive. Other states do the deep dive up front. And so again, this is one of those, unfortunately, there's 50 states. And so every state's a little different, but you can ask those questions on the front end just so that you can set those expectations. In the end, I think it's fair, maybe we should lead in with this, like compliance. The regulators are not here to shut you down. They are not here to hunt you down and to be jerks. Like Terria is very nice. And we have a couple of ex-regulators or prior regulators on the team. They're all very nice people. And Terry, maybe you can speak to this, like from your perspective, like it's all about consumer protection, right? Like in the end, that's what every rule, every regulation, every question sort of is geared towards.
I agree to that. I think that, at least in Texas, that was always our mission statement, is that we were there to protect investors. And so I think in registration, their goal was to block bad actors from being able to do an extensive job and review of your application. And then on the audit side, it is like all of your compliance documents are important, but the focus is like what was communicated to the client, and that conflicts of interest were minimized to the extent possible in order for advisors to meet their fiduciary duty.
Daniel and Stephanie, can you just talk about your registration process? I honestly don't even know if you used XYPN at the time, so not to pat on the back here, but just like, what was your process for getting registered? How long did it take? And any words of wisdom for those who are approaching that point in the process? Daniel, I'll start with you. Sorry, you're first on my screen. So
okay. I worked with a compliance consultant. Jim Cullen, I'm sure.
Oh, yeah. Yep.
I think it was through XY Planning, but I can't remember exactly.
2014, that would have been, yeah.
Yeah. So, I think I'm in Kentucky as the primary state. I think it took 2.5 months, and it felt like extremely thorough, but it helped having Jim's very good. I've had a lot of experience with a lot of different states since then, but Kentucky is very thorough.
Was Anthony McKinney still doing the registrations back then?
Yeah, there was an Anthony. But I don't think there's an Anthony anymore. We have audits every 18 months.
18 months.
Yeah.
Wow.
Recurring audits. So that's always fun. And then you have
to pay for.
Yeah.
You have to pay for the audit. Exactly.
Treatment. Here's a check.
Yeah, I remember the first time I got an invoice for an audit, and I was like, "What is this?" Like, I didn't have money to pay that. Like, I'm just trying to make a living. I want to ask you more about the ongoing compliance, but let me push that into the next section. But you did mention there that you've got a lot of, you're registered in multiple states. So I guess what has that process been? Just, I guess hit 3 clients, 4 clients in a state, go ahead and register. Do you try to avoid registering in other states? How do you look at that now?
We have had a very wide range of experience with the different states. We have physicians, we work with physicians, so they move a lot. So it's extra challenging because we have a daily changing client count. So we got several hundred clients all over the country constantly moving. So this is an extra challenging subject for us, but I think we're registered in 15 states now. So we're registered in 15 states, but we're not SEC because you have to be above the threshold to be SEC. But I need to register before we're above the threshold so we don't break the law. So it's quite a challenging. We can go from 2 clients in one state to 7 in a matter of a week.
Oh, wow.
Especially in July, because that's when all the doctors move. So it's a very, if you're going to go virtual, it's a huge deal, and you have to track it, have a good system for tracking it. And we've had states that take 4 months to register us, like non-resident states, and they don't have a thorough process. It's like, what were you doing? And then other states, it's fast, but they drill in and they make us change our contracts. We have different contracts for different states because some states are like, well, you need to use our special language. And so it's all over the place.
All right. And the threshold you're mentioning, it's what, 100 million in AUM or registering in 15 states, right? Doesn't that trigger SEC, or it's more than 15?
I'm not going to say it because Chris or one of you guys will know how to say it better than I will.
Yeah, the state exemption subject registration requirements in at least 15 states. You can call for SEC registration. That is very narrow in terms of you need to have that tracked closely, and then if there's a period of time where you are no longer subject to registration 15, which kind of Daniel's here with just how quickly that changes. It's at the time of application, though, you have to be subject to the registration requirements in at least 15 states.
Yeah, right now we have 4 states with 5 clients in them. So we're registered in them. But
you're not. But are you subject to registration? No. Okay.
I'd be interested in actually have some dialogue with Chris on your interpretation of that. To me, it makes sense. So yes, you are still subject to de minimis, technically in that state. But what you have 2 options: you either become registered, if you expect to have more business, can you indicate that ultimately, you were in an effort to avoid violating the state's regulation, you were ultimately becoming registered in that state, or do you have to become registered in that state in order to rely on that? Do you run into that very often, Chris?
It's it's funny you should ask, because I recently ran into this exact issue with another advisor who was not meeting the $100 million threshold, but was bumping up into the state threshold. And without this being legal advice, my advice to this particular client was, look, if you're at 5 and you have a client that has, is verbally indicated to you that they're ready to come on board, but for the fact that you literally can't sign an agreement with that client because you're not registered in the state, to me, that's enough to show the good faith desire to be meeting the SEC application criteria where you're required to be registered in a particular state. In other words, to me, the requirement kicks in because, like I said before, you have to be approved before you take on your 6th client. So the super conservative approach would be, which it's hard to argue with based on the plain letter of the law, to actually get approved in 15 states and be above that 5 client de minimis threshold. But if there's a good faith, clients ready to onboard type of arrangement that you can make, argument that you can make, I've gotten comfortable with moving over to the SEC at that point.
Yeah.
What I will say is I have another client who is registered with the SEC on that 15 client threshold. And when they were first examined by the SEC, the one issue that they focused on in the course of the examination, amongst other, but the primary focus area was, show us the justification for your basis of registering with the SEC at the time that you applied. So we need to see dated contracts that are dated at the time of the application or before, show us basically an entire state-by-state breakdown, et cetera, et cetera. So if you're going to go down that route, just make sure you have your ducks in a row from a documentation perspective, because the SEC is going to focus on it just because it's so out of the ordinary. They're used to like $100 million of private fund advisors or internet only advisors, not the 15 or more state advisors. Those tend to be a smaller subset that are, scrutinized a little bit more.
Yeah, thank you for the clarification. I had no idea that it was, I just thought it was 15 states. You just go get registered with the SEC. It's a lot more than that, especially if they're asking you to prove that you needed this 2 years ago. That's a fun thing to try to go back and get out of your CRM data.
Right.
And there was a clarification that came through. Just if you have the 15 state registrations, do you also need to have 100 million in AUM? And the answer is no. It's one or the other. If you hit 100 million in AUM, you register with the SEC. If you are now required to register with 15 states, you can be registered by the SEC, right? It's not necessarily required. The states push you out. They don't want you at above 100 million. You can. And then if you're an internet only, but that's really not like a virtual only financial planning firm, that's more like a robo advisor and that type of platform, then you have to register with the SEC.
I would also throw some clarification that I totally never understood until recently. Is that when you're SEC, I always thought, oh yes, I can't wait to be SEC because we don't have to deal with all these states and pay them so much money and register. And I realized recently that you still have to pay the states money and you still have to deal with notice filing and still have to deal with tracking the numbers in each state. And they'll come after you in some cases if you're not right at that 5. And they still have similar rules for notice filing. Like you got to have that 5 client threshold. And when you exceed it. So it's kind of like the states you always have to deal with is the way I view it.
Well, and not to throw an even bigger curveball, but it's like the SEC, Terry spoke to Texas and Louisiana. If you get 1 client, you have to file a notice filing. But if you're SEC registered, it's 2 different states, right? Nebraska and help me
New
out.
Hampshire.
New Hampshire. There we go.
New Hampshire.
So if you're SEC registered and you can have up to 5 clients in Georgia, but if you get 1 in New Hampshire, it's de minimis. Anyway, fun stuff. But Texas and Louisiana fall off the list. So all good things to be monitoring. I guess this is why the poll question was all the above on what is worrisome about compliance. Admittedly, let's be honest, the state regulators are still catching up to what this means to have Daniel in Kentucky with clients all over the country in all these different states, and the states are just being sure the consumers in their state are being protected, and Kentucky's being sure Daniel's not acting a fool in their state, doesn't want him making them look bad and robbing consumers. So it's like it just creates this complex web that they're still working through. I do want to get to ongoing compliance, but we keep getting great upfront questions. So 2 more of these, and then we'll move on. So whoever of our compliance folks want to answer this, when we talk about de minimis and these number of clients, is that number of humans or is that number of contracts? Because if I have 5 married couples, I have 10 humans, but I only have 5 contracts. What triggers it? Is it households or people?
Yeah, so I mean, this is, obviously the SEC has their definition of a client, and then the states, in many cases, are consistent with that. I would say, if you want to say almost in most cases, states are consistent with the SEC definition. But typically, a client can include, for purposes of de minimis, anyone in their direct household, whether that's a spouse, a dependent, a family member that is going to be involved in that relationship, can be considered a one household client. And I think an important thing here too is to make sure that you're consistently the way you're counting clients is done in a consistent manner, that you're not unless you have a good reason to, if you have a spouse, you're for in the practical sense, you're treating them as separate clients, they have separate agreements, which I do know for many firms does come up. But for purposes of de minimis, that one client is the individual in their direct household.
Okay, awesome. There's another, I appreciate Bruce's question. Is anyone trying to simplify this process and get the regulation to catch up with technology? Chris and Teria and Travis and almost 1,600 advisors here at XYPN would love to see that happen. There is work being done. And so the state regulators, there are 50 of them, they have an overarching association known as NASA, 2 A's at the end. And they are basically, they don't oversee, but they're sort of the association of all the state regulators, and they create model rules, which is why many states have the same rule on their books. The problem is they don't have enforcement of that. So like they can't require the states to use them. And so every state in the end creates their own rules and regulations, and the legal, what happens at the legislature level, like all of those things contribute. And so unfortunately, it's one of the pieces that makes our business unique, and one of the high levels, one of the pieces of complexity that we have to deal with. So one more question about the registration process, and then we'll move on. And that is, there's a lot of talk right now and just a lot of advisors that are moving in sort of the advice only model, where they're doing financial planning, but no asset management. They don't even have the capacity to manage investments. So, advisors have been doing this for a long time, where they were just doing hourly work, or maybe they're doing retainer project fee. Does the registration process or just overall compliance burden in your mind change if all I do is financial planning and I don't do anything to do with investments? Do I still have to register? Is the registration process faster, and then sort of ongoing? So,
yeah, I can tackle that at least initially here, and feel free to jump in, Terry or Chris. Is not necessarily. So ultimately think of what requires RIA registration. Well, in a regular, you are compensated for providing investment advice, to consumers or other parties as a regular course of business. It's kind of an overly simplified paraphrasing the definition there of an RIA. So you're compensated for providing investment advice. Most of those firms that are RIAs, especially traditionally, are managing assets. So especially at the state level, many of the regulators are just used to firms that are providing investment management services. They have assets under management on a discretionary or non-discretionary basis, and they may have custody of those assets. Now, if you have custody, there's additional. You have direct custody of client assets. There may be additional things that come into play. Usually is, but outside of that, it's just the fact that you're managing client assets using an independent custodian, and then you disclose whether or not you're taking on discretionary trading authority of those assets, doesn't in and of itself make the registration process more difficult. It really depends on the view of the regulators in your state, the view that they have on whatever alternate model that you are using, whether it's, it's usually pretty easy to get through with hourly planning, because you're charging a reasonable hourly rate for a set amount of services that you invoice the client on whatever, if it's on a monthly basis or as work is completed. It's hard to really argue with that. We do have some states, Washington State being one of them, that really push back on the ongoing fee-for-service financial planning model. They, for lack of a better phrase, they kind of refer to it, they have referred to it as like the gym membership model. It's something they think your clients are going to pay for, but never actually use. Therefore, you're not earning anything, and there's too much risk there. It's ultimately, XYPN, that's something we take very seriously in trying to help those states and those regulators understand the value you're providing to clients in those areas, and how to make sure that you're doing it in a way that will satisfy their regulations. Many states, their rule, what they're relying on when they challenge these models is, ultimately that they're in a lot of states, their rule around fees is simply that it's a prohibited practice to charge unreasonable and excessive fees. Leaves a lot of room for interpretation. Many states have standards, data that they've collected to assess kind of what an average or the kind of the baseline or the standard fee is with RIAs. But anything outside of what they're accustomed to seeing is what creates questions. So having clear disclosure and being prepared to have conversation with them around the delivery of your services on a continuous basis, and how those services justify the fee that you're paying or that you're charging clients is really what's going to help answer those questions quickly and keep the process moving forward.
Terry, can you speak from your perspective as someone who worked on the other side of that, the desk in those conversations, of just like financial planning versus AUM versus both, and just how the securities regulators are looking at this?
So for financial planning, if you're charging on financial planning, essentially it's just proving that you have provided services on an ongoing basis for ongoing financial planning. And I think that's what they are focusing on right now. At least what NASA is focusing on is just advisors, again, in that gym membership model, who charge extra, especially if you're charging both, if you're charging investment management and a financial planning fee. It's just collectively, one, how much is that fee? So and how big of a client is that? Like, how many assets, or what are the assets under management? Because collectively, that excess of the industry standard, which in some states that's 2%, in some states that's 3% of assets under management. So that's one concern. I don't think traditionally, most firms, the majority of firms, are assets under management. So that's what regulators are used to looking at. And there's less pushback with that model. If there's something new, then obviously there's going to be more scrutiny with something they haven't seen.
Yeah, great point. That and I'm glad y'all were able to address that, because I do hear a lot of like, oh, well, I only do planning. This will be super simple. And if anything, sometimes it can be a little bit more complicated, because to your point, Terry, the regulators are just used to seeing AUM day in and day out. That's simple. And we have all the data. We work with the regulators. We're working with NASA to show how many hours you all are putting in with your clients versus how many hours investment advisors put in, and who's having to prove what, try to level the playing field. But it is a bit of a shifting industry right now. And one more question for you, Terry, just because it has come through now twice. How long does the registration process take in Texas? So is that the 8? Are they on the shorter end? Or are they on the longer end? What's been your experience?
I would say they are on the average. So that 8 to 12, it shouldn't exceed 12 weeks. So you wouldn't have to worry too much about Texas.
Perfect. Okay. All right, we're going to flip over to our last poll, and then we'll sort of get into our last section and open it up for more Q&A. So just opened it up. And so just for our information, and so that sort of with some of this conversation can direct the conversation a little bit based on where everyone is at. But that is sort of, when are you planning on making the transition? Whether that's, transitioning out of BD world and opening your own RIA, leaving an RIA, starting your own, if you're a career changer getting started. So sort of, what is your time frame? Like, do you know, you may have no idea, you may already have, and you're here having already launched an RIA, that's awesome. But just sort of curious, sort of what your time frame is, and, helps as we're sort of catering this conversation, because, we talked about the registration process, but Chris, what is your typical advice for how long it takes to prep all the documents? 6 to 8 weeks once it gets there, but it's a lot of documents to get written first.
Yeah, no, exactly. I mean, what I will say is that if you're going SEC right out of the gate, it can be a more compressed time frame because the SEC only looks at your ADV1, your ADV2A, and your Form CRS. They don't look at the 2B. They don't look at your advisory contract. You don't have to submit your financial statements. You don't have to submit a lot of the other ancillary documents that you would at the state level. So that, in comparison, is a little bit shorter. On the state level, at least on our end, we typically ask for about 3 weeks or so. There are a couple administrative matters that also have to be taken care of, like setting up your IARD user account. That can take a couple days to about a week or so, making sure all the credentials are set up. And then also the way that we work, and I'm sure XYPN does a similar thing as well, is sending out a questionnaire that has to be completed. So it's also dependent on how fast the new registrant completes the questionnaire, setting up time to iron out any difficulties or missing information. And sometimes even too, there can be things beyond our control on the legal and compliance side, insofar as whether the firm has got the LLC established, whether they have bank accounts set up, whether they're able to make deposits into those accounts to pay for applicable fees or meet minimum net worth requirements. So, you know, the bulk of the work is the drafting of the registration documents, but it's also important to include a little bit of buffer for those administrative tasks as well that are condition precedent to actually hitting the submit button.
Okay, awesome. Thanks for that. Okay, I'm going to close out the poll. Sounds like 6 to 12 months is and then ASAP were pretty high. A lot of you have no idea. Totally understand. We're one of those that say, hey, you show up when you're ready. Because you know this is an individual process. We're talking a lot about the compliance side, and this is a really important part that trips a lot of folks up. But in the end, like, we're really talking about entrepreneurship. This is just how you get registered to be an entrepreneur. And entrepreneurship is a journey that you want to be sure you're ready for before you're taking the leap. So awesome. So sort of final section, just want to talk through is ongoing compliance. So Daniel, I want to start with you because you come from a world, I feel like, or came from a world where compliance is this scary thing that they sort of scare you into. Like, you have to stay with a broker dealer because there's so much compliance and there's so much complexity, and then you go off and you know, you'll never be able to manage your own compliance. So can you just talk about sort of what ongoing compliance looks like? And I'll caveat it with, and Stephanie, I want you to speak to this as well, but just like Daniel, you've got a few employees now, like you're a larger firm, so you may have a little bit more complexity, but just how scary and onerous is the ongoing compliance right now with your firm?
Yeah, I can talk about that. And I'm going to have to jump off in 15 minutes, just FYI. But anyway, so it was very much labeled or kind of considered super scary. And actually in my world, in the insurance firm, broker dealer, it was a lot of stuff. It was a lot of restrictions, really. And I think that's more like the broker dealer side. Like, we couldn't say a lot of things. Like, I couldn't putting stuff out there like on social media or blogs. That was like not even no chance. So that was in that world, there was just there are a lot of restrictions, and there was a lot of scary conversation. Like, the compliance people were really kind of like acting as like the scary guy in the company. I got to where I got to know the compliance people in the organization and realize, you know, it wasn't quite as scary as they made it out. But in the world, so when I transitioned into when my business was starting, and it was actually like considerably simpler, even though I was like in charge of it, because we were one state. Originally, we were just one state and just an RIA, no dual registration. So we like got rid of all when you get rid of the broker dealer, I learned that it got rid of a lot of the complexity. And if you're just one state and small RIA, it's super simple. Now, when we started to add states and add people, it got a lot more complicated again, but it's like a different complexity.
Awesome. Okay. And apparently, yeah, I don't know how to read a clock. So yeah, we are done at the top of the hour. So I apologize for everyone. I had another half hour marked. So Stephanie, can you speak to your experience as well, being, I guess, how large is your firm? Do you have employees, or is it still primarily you?
I have one full-time employee, and I added this person this year, 2021. Okay. I mean, honestly, the best compliance is common sense, you know, and just not doing anything stupid, which you probably already know if you're in this business working as a financial advisor. The difference being independent for me was really getting more organized around keeping your documents on file and all of these things. And an audit will definitely help in that regard. So I had my first audit at the end of last year and realized that, I had been thinking compliance is pretty easy. It's a no-brainer, just have common sense. But the audit really helped me understand that I need to keep really good records. And not that I didn't have good records, I just didn't have them as organized as I needed them to be able to readily produce them. And so that was a learning experience, and some advice that I would give is just really being as organized as you can and using common sense. When I brought on my new employee, XY planning has been a great resource for me. I've worked with Travis directly. I've worked with another gal, Shelby, up there, who helped me through my audit. But I don't stress about it and worry about it, because I feel that my peace of mind really comes from having XYPN, whom I know they have my back, and I can email any one of them and say, what do I do about this? What do I need to change in my ADV if I bring somebody on full time? So it hasn't been that big of a deal for me. Now, I'm not registered in multiple states and that sort of thing, and I've only got the one employee, but it's been pretty easy, honestly.
No, I appreciate that perspective, because I think, again, we want to take the fear and the scary out of compliance, because in the end, like, this is a process. Every advisor has to do it. It's getting through it. It can be frustrating. It does. I appreciate your point that it does maybe just take a little bit more attention to organization and detail, because it's one of those things that, you don't think that it matters of like, can I run a report that shows the date, the date for every signed contract or every terminated client? Like, it is, because the regulator at some point will show up and ask you that question. Show me your terminated client file. I remember having to create that when I had no clients. It's like, show me your terminated client file. Like, here it is, empty. I would like to fill up the agreement file first. But that's just that they want to be sure you have it. And I don't know, Daniel and Stephanie, did you feel like your first audit was really them just helping you get set up? Like, it was a little less like, I don't know, maybe that was just my experience. It was a little less nitpicky than I expected. A little bit more like, hey, like, do you have this set up? If not, let's be sure you have it set up. Sort of sets you up on the right foot, was my experience anyway.
Yeah, I'd say that's fair.
Daniel, how was your first audit?
For me, it was not that way. It was more like, let's find holes and don't let it happen again. But I mean, it was, they didn't like, they gave me a chance and they wanted me to correct the issues, but they were kind of they were looking for little things. That's how it felt. I mean, that's how any audit is. It's like, feels like they're picking at you.
Yeah. It's like they actually read your policies and procedures. And so many of you took a template, or you got your buddy's policy and procedure manual, and then you never actually look at it again. Like, read your policy and procedure manual. You got to know what's in it, because many times that's what an audit is all about. I've learned this when we've gone through data security audits. It's actually a lot less about like literal data security practice. It's, what did you say you were going to do? Did you do it? Can you prove you did it? That can you prove you did it? That's the part that's hard for me, because I'm not a note taker. I don't take I don't record everything. So it's like, literally, we had an auditor ask us, like, well, you say these are your core values. Your policy and procedure manual says you review those core values at least annually with your team members. Can you show documentation of when you did that last review? I'm like, no. So like, so that it's a little bit different kind of an audit, but in the end, that's what the auditors many times are doing. Is they have they have their own rules and regulations, but then they're also looking at, you said you were going to do this thing? Did you do it? Did you document it? And so, Terria, you're working, one of the services we provide here at XYPN that Terria is part of is sort of an ongoing compliance consulting program. How much time should folks who are getting registered, who are now getting started, like, how much time should they be dedicating to ongoing compliance tasks, processes, updates, and all of that on a monthly, quarterly, annual basis? Sort of, what's your recommendation there?
It really depends. So it really depends on your firm's practice. So if you're financial planning only, I feel like you have a little bit less tasks than someone discretionary investment management as a service, because you're not reviewing trades, or you're not reviewing your own trades or employees' trades because you're not trading. So it depends on your practice, but I would generally recommend like setting a time, like an hour a week, to dedicate to just spot checking certain things. So setting up a compliance calendar is what I would recommend, and having quarterly or annual tasks. And again, the more employees you have, maybe those will be on a more frequent basis, like a monthly task. Or if you're billing on monthly tasks, then that would be a compliance task, is doing fee calculation, that your bills are accurate. So not a straight answer, but
an hour a week.
I
I
would
think that's
allot an hour a week.
a fair, and if you're thinking about launching a firm, understand you don't spend 99% of your time in billable time with your clients. We spend a lot of time doing businessy stuff that you don't get to bill clients for, such as compliance tasks. So, well, listen, I know we're running up to the top of the hour and to the end of our 90 minutes together. So first off, I just want to say thank you to everyone here on the panel for coming and contributing your time and expertise, for being able to share sort of your experience of being an advisor with Daniel and Stephanie, as well as working with advisors, working with regulators, with Travis, Chris, and Teria. So thank you all. Also want to let everyone know, just for those of you who are thinking about joining XYPN, I cannot share my screen because I didn't download the plugin. Apparently, got a new computer, and it throws everything off. It's amazing how difficult it is to get a new computer. But anyway, this will come out in an email. But just know, for all of you who were with us today, if you join XYPN by the end of the month, you'll get 2 free hours of compliance consulting. So it's a $600 value, and so that time is with folks like Teria or Shelby, who was mentioned earlier. We have a 3 or 4 person team now of compliance consultants who many of which were prior regulators and auditors, but can provide overall expertise. So if you join before then and use the code that comes out in that email, then you'll be able to get signed up for a couple of hours with one of our compliance consultants. So thanks everyone for joining us today. Hopefully able to get your questions answered, and look forward to having you join whenever it makes sense, and see you on that entrepreneurial journey. So thanks everybody, and I hope you have a wonderful rest of your day.